Hey, good afternoon, everybody. This is Jorge Newbery, founder and CEO of AHP Servicing, and today we're talking about how to appoint receivers to generate rent during foreclosure. And this is targeted to you if you are an owner of non-performing mortgages. And I welcome Patrick Decker from Activist Legal to the line. Hi, Patrick. How's it going? And you're on mute, or your audio's not working. And I see people still logging in, so I'm going to give them just a moment. And let's just see.
Off mute now,
there
George.
There you go. You're good now. You're good. Okay. Thanks. Thanks, Patrick. Okay, so we will get going. So again, my name is Jorge Newbery, founder and CEO of AHP Servicing, and with me I have Patrick Decker of Activist Legal. And today's presentation is for non-performing mortgage owners, how to appoint receivers to generate rent during the foreclosure period. And so let's see, what we're going to do is talk about when you need a receiver and how to find one, how receivers are paid, what are the legal requirements, and the roles and duties of the receiver versus the servicer. And as always, we will answer each and every question that you have. At the end of the session, you can chat in a question at any point, and we will answer them all at the end of the presentation. So let's, the first question is what a receivership, but let me step back and kind of share how we started doing this, because I think most of us are familiar with receivers that in a multifamily, a large multifamily, excuse me, a large multifamily property, an office building, a shopping center, any situation like that. You have a large property, you have revenue coming in, and for whatever reason, the property owner is not paying the mortgage. So what can be done in that situation? The mortgage holder can go to court, request that a receiver is appointed, and that receiver can essentially intercept the rent. They're going to take over the operation of the property. They're going to direct all the tenants to start paying the rent to them. They're going to take over insurance. They're going to take over paying the utilities and all that. They're going to basically operate the property as an independent third party and make sure that the mortgage holder, to the extent there's excess money, that they get paid. So that is the role of a receiver. It's not just to collect rent and make sure the property owner is not simply keeping the money, but the mortgage holder is paid, but also to take care of and maintain the property during the foreclosure action. And if the homeowner or the property owner reinstates, great, pays off the loan, great, they get possession back. But during the receivership, the receiver has possession of the property, not the property owner. So now historically, this has worked on those big buildings, the large multifamily, the office buildings, shopping centers, strip malls, stuff like that. It has not been used widely for single family residences. And what is the reason for that? There's one reason: cost. The typical receiver is an attorney. They're going to charge hundreds of dollars an hour. They'll often not manage the property themselves. They'll often engage a property management firm to do the property management. So here you have a couple layers of costs. You have the attorney who's billing by the hour. You have the receiver who's charging their property management fees, and then other costs. And all of a sudden, you say, hey, great, on a single family residence, now the property owner isn't making off with the rent, but now the receiver's getting paid probably more than the rent, and now you're paying their bills. So that doesn't usually solve the problem. So the solution that AHP has been advocating for in tandem with Activist Legal is appointing real estate agents as receivers. And these real estate agents will get paid like a property manager. They'll get paid 5 to 10% of the rents are collected. They'll probably get a bonus for renting it, maybe half a month's rent or a full month's rent. They'll get some kind of fee for helping oversee any repairs that need to be done to the property, and in order to get it rent ready. And that is the if we do all that, and it's done by the agent who maybe has hopes, if this goes REO, that they'll get a listing. There's no guarantee, but they may get a listing. And so if they do 10 of these, they may not get them all, but they may get 6 or 7. And so acting as a receiver creates a pipeline of future listing opportunities and some present, some income in the present where they can get a modest fee for being a receiver and managing the property. So that works. So if you're collecting $2,000 a month and they're charging 10% of it, and that's $200, there's $1,800 left over, which can be applied towards insurance, towards property repairs, towards expenses of holding costs. And if there's something left, great. It goes to the court clerk in some cases, it goes to the servicer in other cases, but it's all used for the benefit of the property, which is ultimately for the benefit of the mortgage holder. And once all is said and done, let's say the property is foreclosed upon and there's an excess, that can be applied to any amount that's remaining to be due on the mortgage. So that's my long intro to let you know that we've done this many times in many states, many times represented by activists. And you may ask, well, where in the documents? Because people often ask this, because in a commercial mortgage, there's going to be specific language which authorizes the mortgage holder to engage to have a receiver appointed in the event of default. It's often in there. In a residential mortgage for a single family residence, it's never in there. I've never seen it. So you're going to court and you're saying, hey, we want to do this. It's not provided for in our documents, but this is why we want to do it. And usually it's a public policy argument stating that this property is vacant. As a result, to be clear, this is only going to work on if you own a non-performing mortgage that's secured by a vacant or tenant-occupied property. If it's owner-occupied, or if it's occupied by a family of the owner or anything like that, this won't work at all. But if it's vacant, or if it's definitely tenant-occupied, then it can work. And if it's vacant, the argument is that this is a blight, or could be a blight, and we are going to repair and rent the property, which will help maintain it. The neighbors will probably be happy, the community be happy, and ultimately it's good for everybody. And that's our experience. And so far, based on that argument, the majority of the time, or I don't think we've had it rejected once, and that covers multiple states. So it is something that we've had some success with. And now you're taking a mortgage which is sitting there. If you're in New York and it's taking 2 years or 3 years to foreclose, and you have a $75,000 home in Syracuse that's sitting there vacant, and you're having to pay to maintain it, pay to shovel the snow, pay to cut the grass, all of a sudden, now you have a tenant in there who's paying rent to the receiver, and now some of that rent is paying for all those things, and the property's better maintained, less at risk of vandalism. So huge benefits for the non-performing mortgage holder. So that was my kind of preamble to this whole presentation. Patrick, do you have anything to add to that?
Yeah, it's really, and also we can talk about, obviously I'm an attorney. We're here with Activist Legal. We handle the foreclosures, evictions, default work, and also the receiverships for pre-REO and other clients. There are a number of legal kind of considerations and factors that a court will look at. George mentioned almost all of them. Another factor to think about is, or George mentioned it, but it's really important, is the condition of the property. Is it in risk of deterioration, blight? Is it an immediate need? Is there something that is immediately needed to repair the property? For example, is it a condo leaking water on a unit below, or is it leaking water from a unit above that needs repair? If it's urgent, that's always a good factor that the court will look at. Another factor is the borrower deceased? Another factor is whether the property is underwater. Is the mortgage sufficient to pay off the loan, or is it more, or would it be more equitable to let us appoint a receiver, make use of the property, make it performing pending a foreclosure in a state where, for example, like New York, it could take over a year to foreclose. So it's really all about fairness and what the court deems reasonable. Like George said, not every mortgage, or most mortgages, will not have something like an assignment of rents. I'm sure we all have seen mortgages where it says that the lender may come in and make necessary repairs. So we use that. We use equitable arguments. Some states even have specific code provisions that talk about this, but in most cases, it's going to be an equitable argument that's left up to the discretion of the court, and that's where a good attorney would come in and make your arguments for you. Say, well, this is why it's fair. We're not trying to revamp the property and completely redo it. We just want to get it to a sufficient level where it can be productive and be performing while we foreclose.
I appreciate that, Patrick. And absolutely, and to be clear, I don't think there's going to be a time where a judge says no. I think it just hasn't happened yet. And I'll tell you that every time we do this, the property owners serve, so they're welcome to come into court and say, wait, I'm about to pay off the loan, I'm about to reinstate the loan. If they did any of these things, chances are very high that the judge is going to say, okay, well, let's come back in 30 days and see if you did what you said you're going to do. And actually, as a mortgage holder, you'd be great with that. Hey, they're about to reinstate, they're about to redeem. But so far as I know, the ones that I've been involved with, which is probably over 100, I've only seen the property owner or the representative show up one time. And in that case, it was a property in Texas. The homeowner had passed away, and you think, well, Texas is a fast foreclosure state. Not in this case, because the homeowner had passed away, and we had to raise an estate. So then, meanwhile, the property sat there vacant. So we did file the motion to appoint the receiver. The heirs, two heirs of the deceased, showed up, and we're like, what's going on? They were, what's going on? And there was no equity in the property after the mortgage, or in other words, the property value was less than the total amount due on the mortgage. So there's no way for the people to the heirs to sell the property and get any money from it. And I think they recognize this, but we came up with a solution in court. Was that, hey, both heirs would agree to consent to the receivership, and the agent that was being appointed as a receiver was not going to be appointed to repair and rent the property. Instead, he would be appointed to sell the property, and when the sale was completed, each heir would receive $1,000. And that was the solution that we came up with. Everybody was happy with it. 3 or 4 months later, the property sold. The heirs each got their money, and that was it. And the agent, got his commission, got a little fee for the receivership, and everybody was happy. And it avoided the time and expense of raising the estate and going through completing the regular foreclosure process, and also allowed us, mitigated the time that this property sat there vacant, subject to deterioration, vandalism, and other ills. So to go back directly to the presentation, what is a receivership? A receivership is, or in a receivership, a third-party independent receiver, neutral third party, takes control over the management of the property, and they do that at the direction of a court. And that's a key. This can't just be done directly without going to court. A judge has to sign an order appointing that receiver. And who can be a receiver? I'll let you take this one, Patrick.
Yes, the most important factor for who can be a receiver is that the person is independent. They don't work for you. They don't work for us, our firm. They don't work for any lender, or they're not partial to the bar. They're an independent party. That doesn't mean it can't be someone you don't know or recommend. Many cases, that's what we would prefer. As long as that person has real estate experience, can be trustworthy, and is willing to carry out the duties, they can be a receiver.
Appreciate that. Yeah, people often ask, well, can my spouse, can my son, can my mother, can all those? Not the case. But if it is a real estate agent that you have a business relationship with but aren't like related directly to, no problem. It can be a pre-existing relationship. Doesn't have to be somebody like a brand new person. Somebody you say, oh, this is a great agent in Fort Lauderdale where the property is, I want to use them. And usually the court has gone along with the lender's recommendation. Another thing where we've yet to have a court say, no, we're not going to take this particular chosen or suggest a receiver. We want someone else to do it. Usually they go along with whoever is recommended. That's our experience so far. And again, I think they look at it, okay, these are single families. It's a much smaller, it's less, less of a task than taking over a shopping center with 50 different stores in it. There's and so if they have basic real estate experience, that all those things should be sufficient on a resume. To property management experience, a real estate agent, all those usually should be enough to have them appointed as a receiver. So actually, I'll do this one. So when do you choose to have the receiver? So if you have a sale date within 6 months, or it looks like you're going to go to sale within 6 months, probably not worth it. There'll be some cost. It's usually $1,000 to $1,500 to appoint the receiver, maybe $1,000 to to have the receivership shut down at the end. So it does, and that's just in legal fees. So there is an expense to it. So the foreclosure sales upcoming, and I'd say within the next 6 months, it's probably not worth it to appoint the receiver. If it's more than 6 months, it starts getting making sense to do so. Also, if it's in a judicial foreclosure state, the motion to appoint the receiver and that litigation can typically be made part of the foreclosure action. So no separate litigation, it kind of reduces the fees and the cost a little bit there. If it's non-judicial, then this would be a brand new separate action, which could cost money. Well, will definitely cost money, and there's not an existing action to attach it to. If it's, again, property needs to be vacant or definitively tenant occupied, and then what are your goals? If you want to turn this into a rental, then it even if it's 4 or 5 months, it may make sense, because now you get a head start on getting it ready, putting a tenant in there, the foreclosure is completed. To the extent you end up with ownership of the property, then you can keep that tenant in there. Or maybe it's something where they want to buy the property once the foreclosure is completed. So a lot of options, but if you want it vacant at the time and you want to sell it to a third party, then then you'd have to do probably a month-to-month lease if it's only a few months before the sale. So things that you strategically need to decide and work in tandem with the receiver in terms of sharing what your longer term goals are and making sure their actions are consistent with those where appropriate. Patrick, anything to add to that?
That was very thorough. I'll just add one additional cost. Sometimes the court will ask you to post like a nominal bond, which is fine. It's routine, and it's actually good because a realtor that you know and trust can be appointed, and you can say to the court, we're secured because we have a nominal bond. So that's just an additional cost.
Makes sense. What are the receiver's duties? I'll let you take this one, Patrick.
Yeah, so obviously the receiver is appointed by the court. They have to make regular reports to the court in terms of income, monthly income in, repairs made. Sometimes the court will authorize up to a specific amount of repairs or leave it up to the receiver's discretion. They have to, at the end of the case, or if the court orders routinely to produce an accounting to the court of money in, money out. They'll have to pay property taxes, collect rents, disperse the proceeds of the rents, pay insurance, utility services, condo fees, anything that's required just to keep the property in good standing, and of course if there are urgent repairs or repairs needed, to make those repairs as they come up.
Appreciate that. Now, how do they get paid?
So they get paid through the assets of the estate and through the leasing income received. So if there is sufficient income coming in through the leases, that's how they'll be paid. Otherwise, they'll be paid by the lender, or if it's a deceased borrower, by the assets of the estate, if there are any assets to be marshaled. It's completely up to the court's discretion exactly. It'll be detailed in the court's order when they establish the receivership, what the receiver's duties are and what the responsibilities are. And so the idea always comes back to what is fair and for the lender and for the borrower, and what is the best interest of a property which may otherwise be blighted, and the best interest of the community. So like George said at the beginning, we will make strong policy arguments as to why this is in the best interest of all parties, including the community at large.
Appreciate that. That seems like, I believe you hit all the points, Patrick. That's helpful. And these, I'm trying to think of the receivers. Again, when you're working with real estate agents, they're looking for the long term. Most of the cases, they're looking for listings. So keep that in mind. And so they're willing to take, in my experience, a modest amount, property management fee of 5 to 10% during the receivership, hoping for that listing at the end, and realizing they won't always get it, but they certainly like to be first up if that's the case. How do you find a receiver? So if you know a real estate agent in the area where the property is located that secures your mortgage, absolutely reach out to that agent. And if they need pre-REO HP servicing, we've done these, activist legal's done these, so we can certainly provide some boundaries in terms of what can and can't be done and what's expected, but it is fairly straightforward. It's as we covered in the duties slide, it's repairing and renting the property as appropriate, as well as providing reporting, and so very much like a property manager. Now, we also, in pre-REO, this, we've had a number of investors buy non-performing loans secured by vacant properties, and we have created a database. So if you're an agent or a broker and you're looking to become a receiver, then you can go to prereo.com/agent, and you will be matched. You'll be put in our database. So whenever anyone contacts us saying, hey, I need a receiver in Green Bay, Wisconsin, we can pull it up and have you appointed. At least, I shouldn't say have activists recommend to the court that particular agent is proposed as the receiver. It's at the court's discretion who they actually appoint. I'll have you take this slide, Patrick.
Yeah, so we're Activist Legal. Like I said, we operate in every single state and jurisdiction of the country. We have counsel in every single state that's experienced with default services, and in particular receiverships. In states are divided really into two types of states: judicial foreclosure states and non-judicial states. In judicial foreclosure states, we can file a receivership petition within the foreclosure case. That would save on cost. The borrower already has notice of the case, and there's no need to reserve or delay. If necessary, for whatever reason, we can always file a separate suit to initiate the receivership, which is a very straightforward suit. File a petition, serve, and probably attend a hearing. And as long as the request is reasonable, as long as many of the factors that we discussed are there, the petition should be granted. If it is denied, what if a petition receivership is denied? Then we go back to the drawing board. We see if there's any other factors, anything else that we need to do to shore up our petition and refile it. Otherwise, we proceed with foreclosure as is, and then if the property goes REO, then you can make the repairs and sell it and rent it out at that point.
Appreciate it, Patrick. Servicing, just as a reminder, because this comes up occasionally, is that we need you always need to use a licensed servicer to have any interaction with the consumer, with the property owner. That can also be done by a receiver once they're appointed by the court. AHP Servicing is probably one of the few servicers that has done many of these. So I think ideally these are done through AHP Servicing and Activist Legal. That's our plug. But it is a if you go to some of our competitors and say, hey, I want to appoint a receiver, I think most of them are like, what are you talking about? So it's something that we've done as a mortgage holder, and we've kind of created more or less of a system to it, which should be helpful to you as well as the receiver. I'll have you take this one, Patrick, just so everyone's kind of aligned in terms of what the duties are for each of the roles.
Okay, yeah, the note investor can suggest a receiver to be appointed. They also can suggest contractors and potential tenants. They go out and find the vendors and any potential tenants. And the investor has to be independent from the receiver, and the receiver has to be independent from all parties, really. The receiver is court appointed, so they're an officer of the court. That means they have some fiduciary obligations and like financial reporting, and they have to have some experience with real estate in terms of finding tenants and finding vendors to conduct repairs and things like cut grass and maintain the property, pay condo fees, pay taxes, and things like that. And they'll be paid a modest fee, a reasonable fee. And the idea is that the fees and costs that are paid are either come from the lease or they're added to the debt, which is reasonable, assuming that is granted by the court, that request is granted by the court. The servicer, as we mentioned, could be someone like AHP Servicing. They apply the payments. They liaison between the investor and the borrower. In Activist Legal, we work closely with them and pre-REO. They account for all the funds, and they are the primary single point of contact.
Appreciate that, Patrick. and repairing and renting the property. I'll take this one. Receivership court orders, they typically will authorize repairs to be made to the property in the amount necessary to make the property rent ready. They do not authorize typically additions, upgrades, adding a bathroom, changing the countertops to something that's going to improve the resale value of the property. All of those should not be done until the property becomes REO, if it becomes REO. If not, here's the tension that we're trying to avoid: is the consumer comes back, hey, you know, I want to reinstate my mortgage, and yes, they can reinstate. Part of that reinstatement or payoff will include the reimbursement for these costs, but if the costs were unnecessary, what was necessary to make the property habitable, yes, that can typically be added to the amount due on the loan. Over and above that, that extra bathroom, that granite countertop, things that were not necessary, the borrower could take the stance that those were just that, not necessary, and the fact that that work was done has now made it tougher for them to redeem and or pay off. So not recommended that that work gets done. It typically should not be added to the amount due on the loan. So consider that. Essential work can be typically added to the amount due on the loan. Non-essential work typically cannot, and as a result, that non-essential work should be left until after the foreclosure is completed, to the extent the foreclosure is completed at all. Patrick, anything to add to that?
That's it. My rule of thumb is always what's reasonable and what's fair for all parties. And as long as we apply to the court and get specific permission from the court to have the receivership appointed, we should be fine.
Appreciate that. And that's it. So if there's any questions, we'll answer them now. If not, you can reach out to dnormand, who's the Director of Business Development for AHP Servicing, and he can assist. And if you have 1 loan, 10 loans, 1,000 loans, whatever you have, and there's typically a portion of them that will fit this profile where they're secured by a vacant property that probably isn't going to foreclosure sale for the next 6 months. And that is the profile where it could really make sense to have a receiver appointed. So we encourage you to reach out to David. He can get you set up in terms of getting you ready to go. If your servicer is okay with that, I mean, this isn't mandatory that you use AHP Servicing. Actually, it's not mandatory that you use Activist Legal. I will just say that both of us have experience in doing this where other servicers and law firms don't. And so certainly if you want to try this, reach out to David and he can coordinate you with AHP Servicing, and if necessary, he can direct you directly to Activist Legal if that's helpful. You can reach out to Patrick Decker directly. It's activistlegal.com. So we appreciate everyone's participation today. I don't see any questions yet. That means, Patrick, thank you. We did a good job explaining things. But if you have questions later, please reach out. David can assist. And if he doesn't know the answer, then he can reach out to Patrick or myself or someone on our teams, and we can get you the answer. So we appreciate everyone's participation today, and we wish you well in your NPL investing, and we hope we can help. Thanks, everyone. Thanks, Patrick.
Thank you, George. Take care.
Bye.